Apologies, everyone, for slight technical difficulties. I want to talk today about long-term disability, and specifically with regards to private investigator. This is a question that I get quite often by individuals who are thinking of going on long-term disability, as well as people who are on long-term disability and are concerned that their insurance companies have hired a private investigator to videotape them, to look at their social media profiles, etc. So the first thing I think you need to understand, and it's very important for people to know, is that insurance companies do have a right, and they do in fact quite often employ private investigators to test, to check whether or not the insureds that have applied for long-term disability or who are on long-term disability are in fact disabled, and whether or not what the private investigators are seeing aligns with the information that the individual has provided to the insurance company and to their doctor. Now, although the insurance company has a right to hire an investigator, this is not an absolute right. And here's what I mean. Insurance companies are not allowed to tell their investigators to interact with you, for example. The investigators are not allowed to come into your personal spaces. They can't come into your home. They can't they can certainly follow you, but they have to maintain a distance. And so there are certain limitations of what they can do. Despite that, many people obviously feel that this is very intrusive, and it is intrusive. However, what I tell people is that for the most part, even when an investigator follows you and takes photographs and does video, oftentimes those are very limited in scope. For example, I have people calling me sometimes and saying, I've seen this car outside of my house. It's been parked there for weeks, every day, and I'm pretty sure that it's a surveillance company. It's a private investigator. I can assure you that's not what's happening. It is extremely, extremely expensive for the insurance company to hire these investigators on a full-time basis. They don't do that. Now, keep in mind, and I think I've said this before, on this live stream, on radio and TV, I used to work for insurance companies. I used to order some of the surveillance. I've interacted with adjusters. I can tell you it cost them a lot of money. Insurance companies do not like to spend money. So what they'll typically do is they'll select, for example, a long weekend. They'll select a series of days, let's say a Monday, Tuesday, Wednesday. They'll take chunks of time and they will tell their investigators to go and essentially go and drive behind you, or see where you're going, etc. So okay, so clearly this is not comfortable for many people, but again, the insurance company has a right to do so. They don't always do it, but they do it. I will tell you that for the most part, when insurance companies come to me and say we have surveillance on your clients, more often than not, the surveillance is either ineffective, meaning it shows exactly what my client has been complaining of, or sometimes even it actually proves that my client is even more disabled than initially thought. So when you have a private investigator that is hired by the insurance company, it can be a double-edged sword, because the insurance company can actually be in a worse off situation down the road, because the investigator actually found things that are not beneficial to the insurance company and they're beneficial to the individual. Now, one of the things that private investigators now do, and this is relatively new, I'll say relatively, because for those of us who remember life before social media, now they will go online and they will Google you. And so if you have Facebook, Instagram, any other social media that they can access, they will access that. They will try and see if you've posted photos or videos, if you've been tagged by other people. So I tell people, look, if you're on long-term disability, if you have a claim with the insurance company, the safest thing to do is simply to turn those off. Don't use them. Not because you're trying to lie or mislead the insurance company, but because you want to make sure that the insurance company doesn't use whatever information they can gather against you. Remember, anything that the insurance company and the investigators can find on you, they will use against you. They will cherry pick if they can. There are ways to rebut those. There's ways to answer those kinds of allegations when the insurance company says, we found a picture of you at a party, at a birthday party, and you seem so happy, and it even seems like you are dancing. There are ways to explain those things away, without a doubt, without a question. However, you want to, as much as possible, limit the amount of times that you have to explain yourself away, and certainly limit the bad optics that are created in situations where you are posting certain things and those don't necessarily jive on their face with whatever it is that you've told your doctor and the insurance company. So you do have to understand that insurance companies are allowed to hire private investigators. They are allowed to conduct surveillance. They don't do it as often as you may think, even though it does happen because it is expensive, but they do it. So you need to be careful. Now, if you go to a website that we had created called LTD FAQ, Long-Term Disability Frequently Asked Questions.com, you will see a series of memos there that we've created free of charge, and they answer certain questions and they deal with certain topics that are relevant to anyone that has an interest or has questions about long-term disability. And one of the memos there, very, very short, 2 or 3 pages, written in plain English, are about surveillance and about private investigators. So you can go ahead and get more information, or you can reach out to me or any member of my team if you have specific concerns about your particular case, and we will be more than happy to go through your questions and answer any concerns that you have. Now, I want to talk about also what happens, and this actually just happened this week with a friend of mine who's on long-term disability. What happens when the insurance company says to you at some point, you've been on long-term disability for, let's say, 6 months, a year, etc., and they say to you, look, we want to have you seen by one of our doctors. We want you to be assessed by one of our assessors. It's not always a doctor. It could be someone else as well. Well, it's very important to understand that the insurance company has the ability to send you, in fact, to one of their doctors, has the ability to have you assessed. That's part of the obligations that you have under your policy to comply with that. Again, up to a limit. It all depends. It's up to a limit. What you need to understand is that when the insurance company does that, generally speaking, and I can tell you it's in my experience, the experience of many lawyers that do what I do, oftentimes that happens because the insurance company is trying to get an opinion from a third party, another doctor, that potentially would allow them to then say to you that your benefits should end because you're ready to go back to work, or because you're not as disabled as you claim that you are, or your doctors claim that you are. So those third-party assessments, those independent medical examinations and other types of assessments that they send you to, typically are done in order for the insurance company to figure out if there is a way to cut you off. So you need to be careful of those. You have to comply with those, but you have to be careful of those. You have to be truthful. You have to make sure that you provide the information that you need. Make sure you go to your doctors, continue on, carry on with the treatments, but be very cognizant that when the insurance company sends you to those third-party assessments, they are not doing that for your benefit. They're doing it for their benefit. Now, I want to stop here because we have some questions here that I want to address. One question that just came in from Daniel. The insurance company says that I'm non-compliant with treatment. What does that actually mean, and how serious is it? That's a good question. So under your policy of insurance, if you're an LTD, one of the obligations that you have as a claimant is to comply with treatment recommendations provided by your doctor generally. I say generally because it depends on who it is that they're referring to in terms of non-compliance. Let's say your doctor says you should be doing physiotherapy or getting psychological treatments or taking certain medications, whatever. Those are treatments that are prescribed. Now, you need to follow those treatments unless there is a good reason why you should not. So let's talk about the first part. Why do you have to follow those treatments? Well, the point of LTD is to be a safety net for you. The point of LTD is to help you get better so you can go back to work. LTD is not there to simply pay you until the age of 65 and that's it. The idea, unless they absolutely have to, unless you are disabled until that point. But generally speaking, you have an obligation to try and get yourself better. That is a principle in law. It's not specific to long-term disability. It's specific to just the legal framework we have. If you suffered an injury, if you are disabled, if you suffered a loss, you have an obligation to mitigate. That's the legal term, mitigate, to get better. Okay. So if your doctors are saying you should be doing X and Y, you should be doing X and Y, unless there is a reason not to. For example, let's say that the doctor prescribes a certain medication to you, and that medication is making you ill. It's not making you feel good. You can say, I'm not taking that medication, and that's that. Well, that looks like non-compliance. And if the insurance company says that you're non-compliant, and in fact you are non-compliant, the insurance company potentially has the ability to then stop your benefits or not pay you LTD. Why? Because you have an obligation under the policy to be compliant, to go through treatments. But again, what happens if certain treatments, like a pill, are making you feel worse? Well, instead of saying to your doctor, I'm not going to comply, you say to the doctor, this is not making me feel good. I'm feeling nauseous, whatever the symptoms are. And you make sure the doctor records that in their notes. That it's not that you're being non-compliant, it's that this is actually making you worse. And so you can have a discussion with your doctor as to what other types of treatments can be prescribed that you can follow that would mean that you are compliant. So being compliant with treatments is important for you in order to continue receiving long-term disability benefits. But it doesn't mean that you have to do treatments, undergo treatments that are making you sicker or making you feel unwell. It's just a matter of how do you express that to your doctor, and are there alternative treatments? I have had cases, I can tell you, where the insurance company has said to my clients that they have been cut off long-term disability because of non-compliance. As long as my clients were able to explain what happened, as long as they were saying, this did not make me feel good, but I did this instead, and I was talking to my doctors and my treatment providers, the insurance company had no choice but to reinstate the individual to continue benefits. If you're simply saying, I'm not doing anything, I'm not complying, I don't want to hear about any other treatments, nothing, well, then you are essentially handing ammunition to the insurance company to use against you. The insurance company will be correct in not paying you if you're not following any sort of treatments that have been prescribed by doctors or other treatment providers. Next question. This is from Alina. I've been on LTD for almost 18 months. It's about a year and a half. My case manager just said that at the 2-year mark, the definition of disability changes. Does that mean that they're planning to cut me off soon? Potentially. So let's talk about that. Under the vast majority of long-term disability policies, you will get long-term disability so long as you show within the first 2 years, that you are unable to perform the essential tasks of your own occupation. Beyond the 2-year mark, under most policies, again, not all policies, but most policies, the test changes. The qualification, the criteria for getting long-term disability changes. It's no longer can you perform the essential tasks of your own occupation, it's can you perform the essential tasks of any occupation for which you are suited for by training, education, or experience. What does that mean? It means that if you can do some other job that pays you 60, 70% of your pre-disability income, then the insurance company will stop paying you benefits beyond the 2-year mark. Now, most people, again, my friend is included that I mentioned earlier, who have been on LTD for about a year and a half, do get the insurance company, the adjuster, probing to see whether or not the person is better, whether you're able to do something else. They may ask you for your resume. They may have you seen one of their assessors, whether it's a doctor or someone else. They may come back to you and saying, look, we've identified 5 or 10 different positions and jobs that we think you can do. And you need to understand that for the most part, as long as you remain disabled, as long as you're unable to perform any other job, any other occupation that you're suited for, this is important, that you're suited for. You know, if you work in engineering, you're an engineer, chemical engineer, and suddenly they tell you, look, we think that you can go and work at Tim Hortons or Starbucks, nothing against those professions, but that's not something that you are suited for or have education in or experience in. And that applies across the board. So I have a lot of people coming to me saying the insurance company has now listed all these jobs they say I can do, all these occupations, but the reality is I have no training experience or training or education in any one of these. And so we push back against the insurance company. And look, if the insurance company maintains their position, well, then we can go after them legally because they can't do it. It's in their interest. It's in your interest, the interest of the insurance company, to tell you that they're going to end your benefits, that you're going to cut you off at that 2-year mark when that change of definition from your own occupation to any occupation changes. Because once they stop your benefits, they're saving money. They're not paying you. Extrapolate that across the board. I mean, imagine if you have 10 people, each person getting $50,000 a year in LTD, they don't have to pay those 10 people beyond the 2-year mark. That's $500,000 just on those 10 people. If we push back at the insurance company, we will oftentimes either make them change their minds because they'll understand that otherwise they're going to get a legal claim on their doorstep, or sometimes we actually have to go after them and force them into a legal situation where they may have to pay you a settlement. So it's very important to understand that insurance companies can't just unilaterally cut you off with no repercussions. If you cannot work at the 2-year mark, if the insurance company says to you that they believe that you can, or that you're not disabled anymore, or not disabled enough to continue getting LTD, do not take that as face value. This is when you reach out to me, to a member of my team, and we talk to you for free. We can do consultations for free. We'll review your documentation, and we'll tell you what are your options. Is the insurance company correct? Are they not correct, etc. But be very wary about that time frame between being on LTD for about 1 year and up until that 2-year mark. That's when you start getting your adjuster, your case manager on your case, trying to understand and ascertain and probe whether or not they can cut you off at that 2-year mark. Next question here. If you notice a shift in your insurer's questions during recent calls, can this be an indication that they are planning to change something or cut off your claim? Possibly. Again, this ties in well to the previous point about that 2-year mark. Look, anytime that your spidey sense is tingling, anytime that you're starting to see red flags because the insurance adjuster is asking you things that otherwise they would not have asked you, or spending more time on the phone with you, or telling you that they may want you to be seen by one of their assessors, doctors, maybe getting treatments from one of their companies, anything like that, anything that seems out of the ordinary, including a shift in their tone, in the questions they ask you, may indicate that they are now probing the possibility of perhaps cutting you off, stopping your benefits, or at least setting up the stage, taking the necessary steps to lead up to the point where they can tell you, sorry, but we're not paying you anymore. So you have to be very, very cognizant of that. What I tell people is keep notes for yourself of your conversations with the insurance company, confirm calls with your adjusters after the call. Just simply write an email to your adjuster saying, we had this call today. This is what you asked me. It's what I said. Again, don't be confrontational. Don't be overly nice. Just be very formal. You want to have a written record. It doesn't have to be long. And if you're not going to do it, if for whatever reason you don't feel comfortable, then keep notes to yourself about that conversation. We need to have that information in the event that we have to go after the insurance company if at some point they do cut you off, they do stop your benefits unjustly and illegally. Let's go. We have some other questions here. Okay. So this is from Sarah, who had asked the previous question about a shift in the insurance questions. For example, she says, what if they ask you more about you and what your days are like? Very, very important. So let's say the adjuster calls you up, and other than asking you how are you feeling, they start asking you about your days. How have you been spending your time? What have you been doing this week, last week? What do you do on Mondays, on Tuesdays? If I got those kinds of questions from the adjuster, I would think to myself, going back to the first point that we talked about earlier today about surveillance. Let's say the adjuster says, what did you do earlier this week? Can you tell me about your Monday, your Tuesday, your Wednesday, etc.? I would be thinking, well, they may just ask it innocently. They may just want to understand more about my condition, what's limiting me, what's bothering me, and whether or not I'm improving. Or perhaps they had surveillance done. Maybe they had somebody do some video and some photographs, and maybe they are trying to compare now what I'm going to be telling them with what they have on record. How do you insulate yourself, inoculate yourself against these kinds of issues? Well, you be truthful. You be truthful. For example, let's say that on Monday you picked up your kids from school, and let's say you went shopping, etc. Nothing wrong with you saying that, and then also adding, if it's true, and when I came back home, I was exhausted and I was in pain, and I had to take medications. Remember, they can't record anything inside your home. They don't know what happened inside your home. So again, you want to be truthful, but provide context. If it appears as though you are describing to them a day that appears completely normal for somebody who can go to work, and that's not in fact what has happened with you, provide the necessary context. Make sure that they understand exactly what it is that you are going through. But yes, certainly, to answer Sarah's question, if the questions begin to change, if the tone changes, the perspective of the questions, the scope of the questions change, they are trying to accumulate more information. And typically that is done because they are looking at your case more closely. Well, why would they look at your case more closely other than to determine if you should continue to receive benefits or not? So again, just be very, very cognizant of the fact that when you're dealing with your adjuster, even if you're friendly with them, they are there for the insurance company. They're not there for you. Okay. So they are accumulating information. They're recording whatever it is you're telling them. One of the reasons why I said that you should be following up with an email, confirming the conversation so that in real time, there is actually a record of what it is that you have heard them say and what you've said in return. Again, Sarah, if you have any more questions on that, feel free to reach out to me directly. Again, it doesn't cost anything for us to chat privately. Okay, getting a question here from someone about, can my job send me for a fitness duty exam? I'm on a gradual return to work and struggling. I'm on partial LTD. So you're asking, can your employer send you for a fitness duty exam? I actually don't know the answer to that because I'm not an employment lawyer. Luckily, we do have employment lawyers, and we will have employment live streams, which will, you'll see next later on today. You will see when the next employment live stream will be, and you can reach out to us as well, and we can get someone to speak with you. But I'll tell you this: if you are on a gradual return to work after being on long-term disability, and you feel that you can't, in fact, do what your job requires, you should be able to go back on full LTD. Long-term disability policies contain a clause. It's called a recurrence clause or provision. What does it mean? It means that when you're on long-term disability, you're on long-term disability because the insurance company has agreed that you're unable to work. If you at some point try to go back to work, in conjunction with them, with the approval of your doctor, etc., you're going to see whether or not you're able, in fact, to maintain this return to work. It could be gradual, it could be limited in basis, it could be that it's on limited hours, limited duties, etc. But the point is, you are trying to go back to work. If at some point you find out that you can't, that you're having difficulty going back to work, maintaining your work, and in fact it's premature, or you're not ready, most long-term disability policies, certainly all the ones I've ever seen, contain this recurrence provision, which usually stipulates that if within a certain period of time of trying to go back to work, usually it's about 6 months, but you got to look at your particular policy and check the provision that deals with this. If within a certain period of time, let's say 6 months, you feel that you cannot, in fact, go back to work, it's premature, you need more treatments, speak with your doctor. Assuming your doctor agrees, you tell the insurance company they should be putting you back on LTD without waiting any time. In other words, your LTD payments should snap back. Can they send you for a fitness assessment or some kind of an assessment? They could, but ultimately I'm going by what your doctors are saying, by how you're feeling. Now, if your own employer is the one that's asking for this, again, that's something that I would want one of our employment lawyers to tell you if that is something that is allowed or not. Because in employers, I can tell you, do have a duty to reasonably accommodate. They can't just tell you that they're not going to hire you back. They have to reasonably accommodate, and it's a fairly onerous obligation that employers have. And if they don't play ball, and you feel like you're stuck between a rock and a hard place, between the LTD insurer that says you got to go back and your employer that says, well, we don't think that you're ready to go back, what do? That's a situation where I would want you to be speaking to one of our lawyers that has expertise in both employment law and long-term disability law, because they'll be able to give you the full scope of advice that you need with vis-a-vis your employment and your insurance. Next question here. This from Michelle. Can I do any sort of volunteer work or something like this while I am on LTD? My doctor thinks I should try to engage in something social to help with my mood. Very, very good question. Let me answer it this way to you. I'm not disagreeing at all with your doctor. I think it's very healthy for somebody, particularly when they're disabled, to try and get back out there, whether it's some kind of work or volunteer basis. But let's look at this from the insurance company standpoint. I always tell people, tell the truth. It takes too much brain power to lie, and insurance companies know that you're lying. I used to work for insurance. I used to be an insurance lawyer 20 years ago. Trust me, it's not easy to lie. So you're going to be truthful. Okay. So you tell the insurance company or adjuster that you've started volunteering, an hour a week, 2 hours a week, whatever. If you were the adjuster, if you're the insurance company, and the insured person who's saying they cannot work is telling you that they're now volunteering doing something, If you're the adjuster, what do you think? You're thinking to yourself, presumably, well, if they can volunteer, can they do something else? And if they're volunteering for an hour a week, can they perhaps work part-time? You know, from an optics standpoint, the insurance company is going to look at this and say to themselves, well, if you can volunteer, why can't you work? Now, I'm not saying that you should not volunteer, and I'm not even saying that we can equate working with volunteering. I'm not saying that at all. What I'm saying to you is the potential optics situation that may arise because of this volunteering that is going to be disclosed, that the insurance company is going to find out. And so you have to weigh yourself whether or not you're comfortable with whatever risk that generates. Because if you tell the insurance company you're adjuster that in fact you are volunteering, that could trigger them looking at your claim more closely than they have been, sending you to assessments, doing whatever they need to do, potentially to try and wean you off benefits, to tell you at some point, we think that you are ready to go back to work on a gradual return basis or some limited basis, etc. So keep that in mind. That's something I want you to keep in mind. I'm not telling you not to volunteer. I'm not disagreeing with your doctor. I'm just telling you, understand the consequences that may ensue if you in fact volunteer and how the insurance company may look at this. Okay. I've been on medical leave without pay, and my employer says I'm still a full-time employee on medical leave. My group benefits have stopped since I turned 65 and was on CBD for the last 4 years. Okay. So you turn 65. The vast majority of long-term disability policies stop at age 65. Not all of them, but many of them. I think what I would want you to well, actually, I'm not understanding what your question is right now, but clearly you are on medical leave. I can tell you I know enough about employment law from our employment lawyers that your employer has an obligation to keep your job open. But it depends on how long you've been without leave. It depends on whether or not your employer says that your employment contract has been frustrated. Again, it's something I would want you to speak with one of our employment lawyers about if you in fact have questions and concerns about your employment. But from a long-term disability standpoint, the majority of policies end at age 65. Next question. I've been on and off with my disability for about 3 years. I've decided to start doing some streaming on Twitch to meet people and help with feeling lonely. Now I have a bit of a following. Okay, it's interesting. Remember what I said at the beginning about private investigators and about them scouring social media and anything else online? I don't know what it is that you're streaming on Twitch, but keep in mind that insurance companies do find out about these things. And I always tell people, look, if you're asking me, should you continue streaming? Should you volunteer? Should you do this or that? There's two things that I tell you. Number one, be truthful with your doctors, with your insurance company. If you can work, go to work. If you can't work, if you are disabled, and whether it's because of a physical issue or a mental health issue or a combination of them, whatever the issue is, anything you put out there into the world by way of social media or even by walking outside, always think about the optics. And I say that because ultimately it's not that it's not about the truth. It's that you don't want to give your insurance adjuster an excuse to stop your benefits. So if you're streaming on Twitch, as an example, by the way, I admit I do not know what Twitch is, but let's assume for a second you're streaming, I don't know, you dancing as an example, and you've told the insurance company that you have difficulty with mobility. You understand that once they see that, they're going to use that against you. They're going to cut off your benefits. They're going to say that you've lied to them. The fact that you have a following, that in and of itself does not invalidate your policy. I don't know what your job is. I don't know what it is that you cannot do with respect to your job. But it's important to understand that you do not want to create a situation where there is a discrepancy between what you look like online and what comes off online and what you're portraying online and putting out there online and what you've told your doctor about your abilities or inabilities and limitations, as well as what you've told the insurance company. Because as soon as there is that mismatch, the insurance company, I'm telling you, will use that against you. Look, we've helped people who've been in that situation, especially when there's an explanation and we need to make sure the insurance company gets it. But you want to avoid that thing altogether. Don't put yourself in that situation if you can avoid it. We have some other questions here, but unfortunately we've run out of time. feel free to reach out to us. Feel free to reach out to me, any member of my team. Again, we'd love to speak with you. We'd love to give you more information for free of charge, just so that you understand. One of our partners recently said to me that our job when we go on these live streams and do video, do TV and radio, is not to even the playing field with the insurance company, is to tilt it in your favor, because the more you know, the more knowledgeable you are about your legal rights, the more the insurance company is unable to take advantage of you and is unable to do to you what they do, unfortunately, to many other people, and other people just don't know. So knowledge is power. So please make sure that you reach out to me if you have any questions. Again, it doesn't cost anything. The next live disability law Q&A is with my colleague Martin Willems, one of the top disability lawyers out there, I can tell you. It will be on Tuesday, February 10th at 10 a.m. Pacific time. And our next employment law Q&A will be on Friday, February 6th. So it's coming up this Friday at 10:30 a.m. Pacific time with Dan Balkaran, again, one of our employment partners. Thank you for joining us today. Again, if you have any questions, please reach out to me, reach out to anybody on my team, and we'll be more than happy to help you, to speak with you. Or if you know somebody who needs help, please tell them to reach out to us. The more people know, the better, the less insurance companies can get away with things that they should not be getting away with. Thank you.